All right. So back to Mr. Huxford, Mr. Laughlin. Why don't we start out with you? Say we're headed here. Have a seat, Ms. Bergkamp. Come on up as well. Mr. Laughlin, or no, actually, Mr. Huxford. You just came in June 11th.
Well,
right?
Ultimately, Mr. Laughlin and I had a conversation, I think Wednesday or Thursday of last week. He indicated that he had some conflicts this morning. I then reached out to my client to see whether or not she would be amenable to a continuance today, and she respectfully declined. So ultimately, we would like to go today. I certainly understand that if the court grants it, that there's a determination of good cause that needs to be made, and if it gets pushed, that ultimately is what it is, I suppose. However, I would note for the court that both my client, her husband, and their associate took time off work today to come down here and rectify the situation, for better or for worse, regardless of the outcome. And furthermore, this was filed prior to my entry into this, and I know there's been at least one continuance, but this case is about 2 months old, if I'm not mistaken. And so in the timeline of protection order cases, that's typically a little bit long in the tooth. And so if we can get it rectified today, fantastic. If not, I certainly understand it. We'll defer to Mr. Laughlin.
Okay, but we just got your notice of appearance last week, so you're still feeling ready to go.
Ms. Bergkamp has been in contact with our office prior to that. She was working with Mr. Hauser, my senior counsel, prior to my entry into this. It is not necessary. I am intimately familiar with the file at this point, and do not need any more time myself.
All right, Mr. Laughlin, still having, and Mr. Kohler, are you there?
Yes, Your Honor.
All right, Mr. Laughlin.
Good morning, Your Honor. I fixed my sound issue.
All right.
Your Honor, the only reason we need a continuance is because I was double booked. I'm out in Mason County where I have court every Monday morning. I was in trial a couple weeks ago, and the person covering for me mistakenly scheduled hearings for this day. So I don't really have a choice. And I did reach out last week to Mr. Huxford about it. My understanding was that they would likely be agreeable. I reached out a few times and I didn't hear back. So I'm out in Mason County right now based on the understanding that we would be continuing it. We don't need a lengthy continuance. I'd request just a few weeks, but certainly I would have.
So do you have a contract out there or something every Monday you say?
I am every Monday morning. It's not a contract per se, but I do appointed work out here.
Okay. All right. And that's Judge Steele on the bench out there?
No, it's Superior Court Judge Goodell.
Oh, I see. Okay. All right. So, so you're not available today because you have a series of cases that you are pre-appointed to.
I have a number of cases out here, and I had requests that the person covering for me not set it for this morning, but that happened. And so I reached out as soon as I found out to Mr. Huxford, and I kind of wish that somebody had gotten back to me a little bit sooner because I could have, tried to get coverage out here. But my understanding was that they were likely going to be agreeable. And so.
All right. So, well, Ms. Bergkamp, I appreciate that you want to get this done, that no contact order that's already been issued, a temporary restraining order under the unlawful harassment laws will continue as it is. We are going to set another date today, give notice to everybody. So Mr. Laughlin and Mr. Huxford, then look at your calendars. Did we lose Mr.
We had discussed.
You may have lost Mr. Laughlin. So 1 second. All right, you're back, Mr. Laughlin?
I'm sorry, Your Honor.
All right, we got you back. So we're going to grant the continuance. I think it's good cause. I find good cause. So have the two of you then talked about a date?
We did kind of preemptively talk about the 1st when we spoke last week. I'm tentatively trying to take a vacation the following week. Not that that is the court's problem, but my own problem. But the 1st would be helpful. If not the 15th, I would prefer not to set it out that long. So the 1st would be my date. Obviously, given the representations from Mr. Laughlin about Mondays, I certainly am amenable to setting this on a different day if that makes
court doesn't have that ability. Okay. So Mr. Laughlin?
Yes, Your Honor, you only hear them on Mondays?
Right.
Okay.
That's correct. So.
Okay, I can make it work with advance notice. I could do
July 1st is the pro-offered date. That's a couple of weeks.
I believe I can do July 1st.
Need to check something else? and I'll go on to other cases and we'll come back to you?
No, Your Honor, I'll make it work. If something comes up, I'll make it work. We don't
Okay.
want to delay it either.
All right. So, and I understand maybe the attorneys have been talking on behalf of the parties. I would hope and expect that the parties would continue to do that and come to, frankly, your own resolutions are always better than the court imposing something. So, Mr. Kohler, Ms. Bergkamp, always best if the parties come to their own resolution. You can make up your own provisions with your attorneys and pro-offer it to the court at any time. But otherwise, we'll be back July 1st for this hearing at 9. Everyone can appear by Zoom or in person, whatever works for you.
Certainly.
And obviously, I've reviewed everything. We were here before everyone was served notice, and here we are today. And how this works is if we're going to hear from your clients or anyone else, I'll need to put them under oath.
Certainly.
And well, maybe we'll just do that now so I don't forget. So I'm going to start out with Ms. Bergkamp. You'd stand up with me. And I guess things are Mr. Huxford, is your client still asking for an order? Is there some resolution that the two parties have made without the
There's
court?
no agreed resolution between the parties. My client would like to move forward today. We received the responsive declaration from Mr. Laughlin and his client. She still would like to proceed.
Okay, no, and then you're ready to go, obviously.
Yes.
Okay,
Yes.
and Mr. Laughlin, on behalf of your client, you're ready to go today.
We are, Your Honor. I brought bench copies of the documents we filed.
Yeah, I was just gonna ask, because the last thing I have in my court file is not anything.
We just got these on Friday, so they're just now getting in the case back.
Okay,
And
so you got some
Your Honor,
copies from
yeah, I
me in
apologize, Your
for-
Honor. My client's internet was out last week. So.
Okay, and so you've obviously already given this to Mr. Huxford, and Mr. Huxford, you got these.
I will make a record of objection while myself and my client had an opportunity to review the declarations filed. I would note for the court that both of the letters are both character references. What they would appear to be. I'm not sure with respect to relevance, whether or not these are really dispositive as to the court's decision today, as to the conduct of Mr. Kolar or lack thereof.
Well, we'll get there first. Let me ask you first. So you've got a letter from June 24th from April Sharp, and you've got a
Yes.
June 28th one from Pam Goodwin,
Yes.
and a declaration.
That is
from
correct. Yes.
Recon. Okay, so, and I'm just getting them. I haven't had a chance to look at anything.
Certainly.
We set this over 2 weeks ago. I think it was, the 17th, two weeks ago, and they're coming in now, and things happen quickly here. So, obviously, Mr. Huxford, you've had a chance to look, and you're ready to make your objections to these and ready to deal with this case with these involved today.
Well, either way, ultimately, I would note for the record the timeliness of the filing, but yes, we have both reviewed them. My client has reviewed them along with her witnesses, who include her husband today. They call as someone to support her own testimony. I would just note for the court, again, the timeliness of the filing. My anticipation is that Mr. Kolar, if the declaration was struck, would be able to essentially assert the same points on the stand as well. And so I don't think it really makes much difference. Again, I think that my primary objection to the two letters that were filed in addition to the declaration, which again, I don't really have any problem with the entry of the declaration, but again, the two letters that have been handed up are both primarily, I've known this guy a long time. He seems like a great guy, and his character is unimpeachable, essentially. So I don't think that's relevant to the factual issues here today. And so I would ask the court to strike those two declarations. But if the court feels like they are necessary, and because we have reviewed them, that it's acceptable to include them in the file, I don't have any objection to that if that is the court's ruling.
Well, I don't know. We're going to accept them. So maybe we'll deal with that first. That motion to exclude the declaration of Mr. Kolar. Is that also a motion to exclude the declaration of Mr. Kolar, or just the letters from Sharp and Goodwin? Mr. Huxford, which are you objecting to? The declaration of the
The
defendant and the
declaration of April Sharp and the declaration of Pam Goodman.
Okay, and I don't know if I can take these as declarations, but I'll turn to you, Mr. Laughlin. I see just a statement. I make this declaration or penalty of perjury, and really finding that that makes them into an affidavit. Are we expecting to hear from these folks today?
No, Your Honor, these
Okay.
are character references. If they were substantive, I certainly wouldn't object to a brief continuance. I also have proof that my client's internet was out. I was fully informed of that. I was out on Friday at a conference and
Okay.
still tried to get it in as quickly as I could, but it doesn't, the court's allowed to consider that under the rules of evidence don't apply in these proceedings, but we're not going to be calling those people as witnesses.
Okay, all right. So, certainly the rules of evidence are relaxed, but I still have to kind of, be able to allow everybody to, I have to be able to judge credibility and so forth and authenticity and all of that. So I have to apply those basics to everything. And frankly, like I say, things happen fast. So I understand when things get filed within that 2-week period and pretty close to even today. So I'm not really finding any reason to exclude them on a timeliness issue, but I would consider, I pretty generally consider continuances if things come in late that everybody needs to depend on, but I'm not hearing that. Mr. Huxford, am I hearing that or?
I mean, I think that if the court is inclined to include the declarations of Ms. Goodwin and Ms. Sharp, ultimately, I would just ask for leave under cross-examination to explore the issue of character. If Mr. Laughlin and his client want to make the issue of character relevant for the purpose of this proceeding, I think that we could proceed under some questioning with respect to character to that effect. And so I would just ask for leave of the court to explore that since it's been put at issue by the respondent.
All right. Well, I'm not sure what weight I'm going to be giving these statements from Ms. Sharp and Ms. Goodwin because, like I say, they're not notarized, they're not under penalty. I can't evaluate credibility. They can't be cross-examined. If you're saying, Mr. Laughlin, that you didn't believe you were submitting them for substance, though.
Your Honor, just I've done about 1 million of these protection order proceedings, and generally, I have found in my practice that it's informative if the client has positive character references. It helps the court guide their decision. I do believe that they would qualify as a declaration as much as their witnesses would, who has really no substantive proof in their declaration either. But I would defer to the court to give it what weight you wish.
All right. And then, but the declaration of your client placed on your law, kind of provided by you with your client present, be put under oath if he decides or decides not to testify, that's fine too. But this has more weight because it's backed by your standing as an attorney under oath and under the laws here in the court rules. So I haven't looked at anything yet. I see that I don't want to get off on, bird walks on things that don't really apply to what I have to figure out here under the laws. But, I understand you're trying to supply, both sides are trying to supply information to help the court. But right now, so I've had a chance to look at a lot of things, and both petitioner and respondent, I'm just always, and what I'm looking at here, just so you understand, is the court file is electronic. I'm having to look at a file. I am listening. But I will occasionally be looking down at 2 screens as you refer to things. So I think I understand the issues here. I understand, I guess my big question, Mr. Huxford, is direct me then to why your client believes this is Mr. Kolar doing all this.
I mean, I think that ultimately what we're looking at here is a nexus based on the totality of circumstances between Mr. Kolar's employment with intercity transit, the subsequent medical leave that was taken, and then the agency declining to continue his employment, Miss Bergkamp's role in that, and then the nexus of time or relationship of his dismissal, the timing through which this starts a subsequent police investigation, which doesn't come to any sort of necessarily conclusion, but then this attenuated over time posting against intercity transit, posting with Miss Bergkamp's initials specifically, which Mr.
First off, now that, and it's City of Olympia Interstate Transit.
That's
Okay.
yeah, that's correct, Jess.
What was the time frame that you're alleging that Mr. Kohler worked there with your client?
Based on his own declaration and the
right.
declaration in the petition with my client, it's my belief that Mr. Kolar worked for Intercity Transit for approximately 11 years.
But you know the time frame, and maybe I'll just ask Mr. Laughlin, because all of a sudden something's coming to mind that, all right, I just need to know a time frame when your client worked there.
Yes, Your Honor, that was back in 2022, I think was when he was let go.
October 22.
Okay, you started work October 22. Okay.
No, sorry, Your Honor. I started March of 2012. And I was let go October 22.
Okay, all right. I'm sorry. I should have figured this out, but I guess I didn't put it together when I was looking through all of this. Your client fairly, Mr. Oxford kept saying an agency, and I just didn't.
Certainly.
My stepdaughter worked for City of Olympia Interstate Transit in Human Resources directly with the previous director. So I think I'm not allowed to hear this case. I'm sorry, I didn't put this together quick enough that it was City of Olympia Interstate Transit. Maybe I should have asked about what agency, but I didn't put it together. But now I'm hearing this and going, all right.
So may I ask a clarifying question?
Sure.
So do I understand correctly that there's a potential personal or professional conflict of interest that I'm hearing? Okay.
That I think I mandated? The appearance of impropriety,
Certainly.
I think we're understanding that more and more with the United States Supreme Court and their family. But so I think that's something that, which really, I'm sorry, I'm sorry that I didn't put this together. And this means, Mr. Kohler, Ms. Bergkamp, that we got to find either another judge. Like I say, we're down to, so not today. It's not.
Listen, it goes without saying that if the court feels that there is even the specter of impropriety, that I do not want to move forward and obviously put my client's case at risk or the opportunity for some sort of appellate review based on a perceived impropriety or conflict of interest. And so if the court feels like it has no choice, then I have to respect that decision. And I actually appreciate the candor of the court to advise us of that position. Obviously, we were hoping to go today, but if that's the case, then I think my hands are tied ultimately in terms of what we can do moving forward today.
So that's what I'm thinking, Mr. Laughlin. It's too close, and I think the appearance is too obvious. I can't say that I particularly, but I don't know. Spent a lot of time with my stepdaughter and that kind of day, whatever. So probably heard about a few things that I didn't know or maybe was associated with this. I don't know, but I can't hear the case. So let's see. Obviously you've heard July 15th is pretty open, but every Monday, start looking at your calendars. If you would, you can open your phones, whatever you need to do.
Ultimately, July 15th works splendidly for me, but
Your client isn't shaking her head. Look at your phone if you need to, Mr. Kohler. And any Monday thereafter, we do it Mondays.
okay.
Your Honor.
My client has informed me that as far as Mondays go, and honestly for me as well, the Mondays are incredibly difficult. He is not free until August. And I think realistically, I will have to ensure that I don't have other cases scheduled for a Monday. So I think we should look to August.
August 5 would be our first Monday,
And I can do August 5th.
and then that gives you time to clear your calendar.
I have nothing in August scheduled, save for some family law proceedings that were just continued to that. That works fine for me. Yes, I can accommodate that. While we would
The order
prefer.
stays in effect. We can set August 5th, 9 o'clock. Can you make it clear that I'm recused?
Yes, already.
Okay, thanks.
Those parties come forward. Now, is there anyone on Zoom for this case, or is everyone in person?
Good morning, Your Honor, Mr. Laughlin. I believe everybody's in person.
All right. So I will start with the petitioner. Well, let's start with introductions. Good morning.
Good morning, Your Honor.
Good morning.
Justin Huxford on behalf of Emily Bergkamp. Ms. Bergkamp is present. There's been a fairly extensive record put before the court already with respect to the declaration and substantive response from the declarant. I do know that Ms. Bergkamp would like to offer some oral testimony to substantiate and support her written declaration and petition.
All right. Let me just pull up some of those materials and go ahead. Introductions of the respondent.
Morning, Your Honor. Luke Laughlin on behalf of Mr. Kohler. We will not have any additional witnesses. We did file some declarations. I do recall, I believe you said Mr. Bergkamp wants to testify.
He's here as well. He may offer testimony at the court's discretion, depending on whether or not the court feels it's necessary.
And I would just object to that. I read his declaration. I don't think that he has any direct knowledge, personal knowledge.
All right. Well, we will get there shortly. And did I call you Jason? Or did not by mistake? Okay.
I don't believe so, Your Honor.
I don't know why I thought I did. All right. Okay. So looks like we had the original petitions. We had a temporary order. I believe the temporary order was reissued once. And we are here now on a permanent order. Is that all correct?
That's correct.
Okay. All right. So I will go ahead and hear from you. If you have additional testimony, raise your right hand. All right, what else would you like the court to know? Try to stick to things that maybe haven't already been presented in writing. So like new information, additional information, any concerns you have for your safety or active threats that you feel you need the court to be aware of before making a decision.
So I think one piece that I would like to share is just briefly, my family and I, there were keys with my name and my home address spread all over Thurston County for the duration of a couple months back in 2023 from March to May. And around that time, Mr. Kohler was making very negative and hateful comments about me on social media. He was also engaged in making many public records requests to the agency I work for, Intercity Transit, mostly about me and my work activities, but also related to a decision that I was a part of that ended his employment with Intercity Transit. So when I reported the key situation to the police, initially we weren't really sure what was going on, but as soon as we got 2, 3, 4 keys with my name and home address on them, we knew someone was doing this nefariously. The police asked me when I called them if I knew of anybody or would I suspect anyone would be doing this. And I said, there is a disgruntled former employee who is actively making negative comments about me on social media. And so after I worked with them for a few days, they also saw some of the information that he was posting on Facebook. And one of the police officers I was working with, Amy King, who's no longer there, but she mentioned, and I'm paraphrasing, that while we don't have proof it's David Kohler, we all believe it's him due to the circumstances. So I asked them what my recourse was, and she suggested I pursue a protection order, which I waited on. I take these allegations very seriously. And then in November of 2023, I was made aware of someone who's connected by on social media with David Kohler that he had made a post referring to me by my initials. And it basically was stating that threatening someone else named Amanda, that you should have learned what happened to EB. You fuck with my family, you know, it's game on. The person who sent that information to me, I know her. Her name is Amanda. In his declaration, Mr. Kolar states that he doesn't remember what that post was about and that he was referring to his stepdaughter, who also has the same initials, EB. However, if you look in the comments of that Facebook post, which is in Exhibit A of my petition, it clearly says that exactly what he's talking about. He refers to this person as a POS. 3 separate attacks on school grounds. I let the first 2 go, but now it's game on. And then he further comments, she's an angry elf trying to live through her daughter and just a POS all around. To me, that sounds like he's referencing a very specific situation. And I just find it hard to believe that the emotional context of that post does not seem to make sense with referring to his stepdaughter's initials as EB. I clearly state that, this is a braggadocious way of referencing me and what he did to me and my family with the key harassment. And now he's threatening to do it to someone else. And that's when I felt like I had the responsibility that this was evidence where it clearly states me by my initials. And that's why I felt like I had enough information to file a protection order.
All right. Is there anything else that you want me to know?
I would say that the protection order, temporary order, has been in place since April, late April of this year. Mr. Kolar has not made one negative comment about me on Facebook during that time or on any social media. Before that, he was consistently doing so. He would take a few months off here and there, but he would consistently do so. And so I find it very interesting that this time the temporary protection order has been in place. It's been very quiet. I haven't had to worry about that. Again, it's his right to make those comments on social media, but it's the chronicity of him making the comments around the time that the keys started appearing in the community that is very compelling to me personally. And I can't understate the terrorizing nature this had on me and my family. We had strangers coming to our door all time of day and night. We never knew how they were going to respond. It also said there was a $500 reward on the keys. So my children were outside playing basketball. Oftentimes strangers would approach. We lived in our house with all the blinds drawn, the doors locked. We told the kids to stay upstairs, to never answer the door. My elderly mother lived in our neighborhood. I was also concerned about her safety. And while, all of this was happening, he was consistently making just negative remarks about me on social media, making public records requests. And I have never once made any negative comments about Mr. Kolar anywhere. And I just find it hard to believe that that he is not responsible for the harassment my family and I endured.
Did you, while any of this was going on, have you been to therapy? Did you have to take medication? How did this impact your everyday living?
This impacted my everyday living because we were essentially just prisoners in our own home. I did increase my anti-anxiety medication around this time as well. When I hear a noise at night, I think it's Mr. Kolar coming to my house because I am very afraid of him retaliating against me because I've even gone this far. And even though it may be his freedom of speech, I guarantee you that after this is over, if I am not provided a protection order, he will start his defamatory comments about me on social media again. I'm 100% sure of that. And I think the hardest part for me was seeing what my kids went through, my 2 boys. My oldest son actually offered to say, hey, Mom, if you know who this is, can I reach out to them and just ask them to stop?
How old are your kids?
My oldest son just turned 17 and my youngest is 14.
And the relationship between you and Mr. Kolar is purely an ex-employee-employer relationship. There's
That's
nothing
correct.
more to it than that.
No.
And were you a supervisor?
I was
His direct supervisor?
for a short period of time, yes.
Okay. And then can you tell the court what happened in that work relationship, how that ended?
Sure. Well, essentially the work relationship, the way it ended was that Mr. Kolar took time off for some medical related absences. It's my understanding that he had needs for some surgeries. Around that same time, Intercity Transit had made a vaccine mandate. This was during the heart of COVID. Had made a vaccine mandate. And it's my understanding Mr. Kolar chose not to get vaccinated, but he did take his medical leave of absence. And when that was over, we require that there's return to work paperwork that is submitted by every employee. It's a standard practice. And Mr. Kolar submitted incomplete paperwork. And so we ended his employment. He was not maliciously terminated. It was simply because he didn't provide the information that we needed to make sure he could return to work safely. Secondary to that, I'm not sure if he was vaccinated at that point in time, but that would have been another requirement of his return at that point in time too.
Okay. And is that the time that this started?
So he was let go in October, I believe, of 2022. In December of 2022, the public records request started, as well as negative comments on Facebook. And then also in early March, when I was named interim general manager of intercity transit, he made very clear negative remarks about me on articles in the Olympian. He's referred to me negatively by my titles. And so to me, the timing and the chronicity of everything, and then followed up by the statement he made this last November.
All right. If I forgot, is it Mr.
Huxford, thank you.
No, your witness. Sorry, Mr. Huxford.
Mr. Bergkamp is with us as
What
well.
can you just tell me what additional information he
I
might?
think mostly to substantiate just the impact on the family. He was present for many of the keys arriving in the house, answered messages, telephone numbers, or telephone calls rather, visits directly to the house from people trying to return these keys to the family home.
Okay.
I mean, ultimately, I think that's covered in his declaration quite specifically. So if you'd like to hear from him,
Okay. The only part I would like to hear about is the impact on the family.
certainly.
So if, sir, we come forward, please, just give you before I swear you in, I don't want you to repeat a bunch of things that have already been presented to the court, but I do want to hear specifically if this situation has impacted you personally and how it's impacted your family, if it has. So raise your right hand, swear to tell the truth and nothing but the truth.
I do.
Okay.
So, Your Honor, absolutely, it's affected us in profound ways. For me, watching my family, my wife and my children suffer, knowing who did it and how this is happening, really the diabolical method in which it occurred, in which I believe we are not the only victims of this harassment, but you had numerous folks who are homeless, who are in desperate need of money. They came to our home expecting something. And it was quite an incredible setup to produce really profound disappointment and anger. Some folks would arrive 2, 3, and 4 in a car when they understood that this was a hoax, this was harassment, this was, I don't know what other word you want to call this, but they were really angry. And so I had very angry, sometimes intoxicated people on my porch, on my property, day and night, constantly. We did not know when this was going to end. We had no clear recourse, and there is no way that this behavior harassment was deserved by us. I know Mr. Kolar in no particular way, shape, or form.
Right. So specifically having that happen, like having the people come to your house, having them be intoxicated, it impacted you in what ways? Like what actually changed in your life as far as, did you go to the doctor? Did you get any medication? Did you do therapy? Did you do anything to protect your family? Like, how did your life actually change based on what you were going through?
I understand that I'm a fact witness, but I'm also a clinical psychologist. I watched myself and my family slowly accumulate symptoms that are related directly to trauma.
Okay, so that's what I want to hear. Just tell me what the symptoms are.
Yeah, I got you. So we are hypervigilant, anxious all the time, pretty much flat and sometimes depressed. We changed our plans. We changed our life. We did not, our boys had activities for school. We had activities for personal life. We had friends coming over. We have family close by. My mother-in-law lives just a couple doors down. My parents live just 5 minutes away. And we were in a state of terror. We did not know where the next threat was coming from or how it was going to find us.
All right. Thank you. All right. So at this time, I will ask you if you would like to present any evidence, or if you would like to have anyone testify. I know you said you originally did not want to produce any additional evidence. I don't know if you.
No, I didn't say that.
Oh, I'm sorry. I thought you.
Not via Zoom. You asked if there were witnesses. via Zoom.
Okay. All right.
Yeah.
Thank you.
Your Honor, I would like the opportunity to do a brief cross-examination of both the petitioner and
Okay.
her husband.
All right.
And then I would like testimony from the
Okay.
client.
All right. So you're still under oath. And so defense counsel is respondent's counsel is going to ask you some questions.
Ms. Bergkamp, I understand that you believe that it's my client that that it made some keys and passed them around to people in the community, correct?
That's correct.
Okay. And you haven't seen my client actually in the flesh in close to 3 to 4 years, correct?
That's correct.
If there were any threats directly issued at you, any threats of violence whatsoever, that you've endured by my client directed at you, they'd be in the evidence you presented.
That's correct.
Okay. Ms. Bergkamp, the key incident, I know you referenced it, is happening in April. I think you said March and April. You're referring to 2023, correct?
Correct.
Okay. So that was approximately a year and a half ago, give or take, correct?
Yes.
Okay. In your declaration, you wrote that you reported it to law enforcement, correct?
That's correct.
And that law enforcement investigated it, correct?
Yes.
And that they determined that they could not determine who did it, correct?
Except for the statement that made by Lieutenant King, which I've already referenced, that while they didn't have proof, they believe it was David Kolar due to the circumstances.
Okay. And they did not charge Mr. Kolar with any incident, did they?
They did not.
Okay. And Officer Watkins was the officer in charge, correct?
Yes.
Okay. And you stayed in close contact with him about the case?
Yes.
And he did not, and he called Mr. Kolar, correct?
He did.
And he and Mr. Kolar voluntarily spoke with him, correct?
Correct.
And after that discussion, Officer Watkins closed the case, correct?
I'm not aware of that. He didn't communicate that to me.
In your declaration, you wrote that you were reasonably certain. You used the words reasonably certain that Mr. Kolar was responsible for the key incident, correct?
That's correct. Yes.
And that was known to you. That was your belief since the key incident began in spring of 2023, correct?
Can you repeat that question?
That was your belief since the spring of 2023, correct?
Correct.
Okay. But you didn't apply for a protection order until a year and a half later, correct?
That's correct.
Okay. And Mr. Kolar had been terminated from his employment many, many months before the key incident began, correct?
It was October of 2022. The key harassment started in March of 2023.
So 9 or so months, correct?
That's less than 9 months, I believe.
Okay. So it's fair to say that you believe he's the most likely individual, correct?
Yes.
Okay, but you're not certain, correct?
I don't have an image of David Kolar making keys in his house.
Okay. Your work building, you had referenced in your declaration that you believe that Mr. Kolar was going to your work building. Was there any witness of this, him coming to see you at your work building?
Can you repeat the question, please?
Yeah, I recall reading in your declaration or one of your statements that you believe that he had gone to your work building at some point. I believe it's to pay for public records.
There was a statement in Mr. Kolar's declaration that I have no idea what he's referencing. I never called law enforcement to state that he was coming to my home or my work address during the time that the temporary protection order was in place. I don't know what that's referencing.
Okay, well, I recall reading, and it's quite lengthy, so I don't have it pinpointed, unfortunately, but I recall reading something along the lines of he would have had to go to your work building to pay for public records.
That is correct. And we have been complying with Mr. Kolar's public records requests in a very efficient manner.
Okay. Are you aware that he actually never went to the work building to pay for public records? It was a different building.
I am aware he went to the transit center downtown, yes, to pay for public records. Okay. That's what we ask everyone to do.
Okay. The reason I ask is you presented that in your declaration as him attempting to contact you. Did you ever try to have your work building collect the camera footage from the videos outside of it?
No.
Okay. Did you ever, do you have a camera outside of your house?
Yes. In fact, we did have to increase the number of cameras that we have security-wise after the keys started showing up. We incurred extra cost as a family to do that so that we could see when people were approaching our driveway.
Okay. And did you ever once see Mr. Kohler arrive at your house?
That information is in the declaration. No.
No. Do you believe Mr. Kohler has a legal right to do public records requests?
Absolutely.
Okay. And those public records requests, you didn't provide any proof of them in here, but you indicated that they were directed at you, correct?
There were many directed at me. There were many not directed at me. There were others directed at just the agency in general.
Okay, so that was left out of your petition, which is that he actually did many public records requests, and they weren't just about you. They were about his termination, which involved you. Correct?
That's correct. And considering the chronicity of all of his negative comments about me on social media, those were of particular concern to me as well, because they bolstered the fact that he was doing this around the time the keys started happening.
Do you recall reading in Officer Watkins' report reference of somebody named Stewart who had texted you a picture of a dartboard, a target?
Yes, so I actually made Officer Watkins aware of that. He called that phone number. It was an adolescent who had no idea what was going on, and I never once received another text message from that number. However, the negative comments that David Kolar was making about me on social media and also his public records requests continued throughout that time.
So I read everything that you filed, and I understand you say that all of this stuff is attributed to Mr. Kohler, but I am not seeing, I've read through everything that you filed, and I am not seeing anything that specifically is a threat or even specifically mentions you. Is there anything that I'm missing here? You're just coming to the conclusion that Mr. Kohler is making what you call threats towards you, correct? But they're not actually, you can't show that anything that he's ever written is about you.
That's not what I'm claiming. I'm claiming that he pursued this course of harassment through a means that it would be very difficult for anyone to identify who this might actually be. But through all of the circumstantial evidence that I have, that I know I have the right to share in this courtroom, it clearly makes points that the chronicity of the keys and Mr. Kolar's behavior on social media lines up with him being the individual who I believe is responsible.
You supervise over 300 employees, correct?
Yes.
A number of them were let go during the COVID epidemic, correct?
Actually, there were not as many as Mr. Kolar stated in his declaration. We had many people resign before the vaccine mandate went into place. And many of those folks I provided letters of reference for so they could find employment elsewhere. There were truly only about 5 people who were let go because they chose not to get vaccinated.
Were you aware that there's numerous disgruntled people who felt compelled to resign or were terminated as a result of the decision of your agency during COVID?
So that is something people don't necessarily tell me about. However, I never once heard from any of those individuals on social media. They've never once made a negative comment about me. So I find it interesting that that they have not done that. In fact, I've not been contacted by any of those individuals afterwards. But Mr. Kolar continues, and probably would, if this is not granted, make negative comments about me and my place of employment.
Mr. Kolar has a right to criticize public officials.
Yes.
And Mr. Kolar has never stepped over the line and made any threat towards you personally, correct?
Correct. Personally, no. And I'm not taking offense to his making comments about me on, it's his freedom of speech right to do that. It's the chronicity of those comments and his behavior that I am pointing to.
Well, the chronicity is this was 1.5 years ago, and you filed for a protection order a few months ago. Isn't it true that Mr. Kolar had indicated on social media that he planned to go to a board meeting for intercity transit in, I believe it was late February?
That's
and
correct.
Right after that, to voice his concerns about how the agency operates. And right after that, is when you sought the protection order. Isn't that true?
I have already stated that I initially did not seek a protection order because I was afraid of Mr. Kolar retaliating against me, and that remains true. The timing of when I put in for that is actually just an indication of the fear that I have.
You had law enforcement involved with you at that time. You had numerous officers involved, and you're saying you're more afraid after nothing happened for a year and a half than you're more afraid now?
That's correct, because they couldn't do anything, and they had many other pressing issues to attend to out in the public. Mine was not something that was taking priority.
Because they didn't have any proof.
That's true, and because they yet still advised me to seek a protection order, including the last.
That was an option, correct?
That's correct. Yes.
The only thing that's happened since the key incident a year and a half ago was that you impart to Mr. Kolar is a Facebook post in November, which is like 4 to 5 months before you filed the petition.
That's correct.
And you referenced that Facebook post, and you said, and it says, it references someone you believe is, I believe you're a coworker, correct?
No, it's someone I know. It's an acquaintance.
Okay, an acquaintance. And you have determined that the initials EB stand for you, correct?
Yes.
But you're aware now that Mr. Kolar's daughter is actually EB, correct?
I am aware that her initials are EB, yes.
And you're also aware that the person that he was making that comment about had falsely accused, had some incidents with his minor children at the school in which they were falsely accused of something and had voiced concerns about racism, correct?
I only know what Mr. Kolar put in his declaration.
Do you think it's a little bit of a leap to just assume that that's you after a year and a half of hearing nothing?
If you had been through what my family and I had endured for months.
Please just answer the question.
4 months.
Yes or no?
I would
Please answer the
suggest
question.
that, can you repeat the question?
I'll just move on. Are you aware that my client actually has a tremendous amount of sympathy for what your family's gone through? Are you aware of that?
I would not be, because he's never once expressed concern for me or my family. He's only expressed criticism of me on social media.
You, in your petition, you indicated that the reason you think it's my client is because the Star of David, and his first name is David, was on the keychains for the keys.
That was on the keychains of the keys, yes. And initially, I felt that it might have been some anti-Semitic issues. However, I have learned recently in the last month that the Star of David was actually used by individuals who were choosing not to get vaccinated as a way to protest the vaccine mandate. There was a Washington State lawmaker, you can Google Washington State.
To strike, please just answer the question. It's a yes or no question.
And sorry, what was the question again?
We'll move on. I would just ask, just answer yes or no to my questions, please.
Also, Mr. Laughlin, just if you can keep your questions to her testimony. I mean, we're going far afield.
I'm trying not to, Your Honor, but.
Well, I mean, and I just would like you to be succinct and maybe make shorter questions. I mean, they are kind of long and it's hard for the witness to answer the questions. So go ahead.
Noted, Your Honor. Ms. Bergkamp, I think what I'm getting at is, this incident, nobody's denying that this happened to you. Nobody's denying that. But it does appear to be quite a stretch from.
Okay, so again, you're not asking a question.
I'm getting to my question.
I know, but that's the problem. So you're prefacing your question with testimony and argument, and that's confusing the witness. And I know it's cross-examination, but you're not asking the question, right? So you're saying, you're prefacing it with a lot of facts, and then by the time you ask her a question, she's not sure what you're asking. So I'm just asking you to cross-examine in a way that the witness can understand and answer the question.
Ms. Bergkamp, everything that you wrote is a statement under oath, correct?
Correct.
And you stated under oath that you never stated that you knew that you had definitive proof that Mr. Kohler was responsible, yes or no?
Yes.
Yes, you have definitive proof that Mr. Kohler is responsible. Is that what you're saying now?
I did not have definitive proof.
Okay, no more questions.
Okay. And do you have any questions of the other witness?
You just won. Yeah.
Okay. Can you just come forward, sir?
Mr. Bergkamp, I read your declaration. I understand that your family went through a lot. But I want to direct your attention to two words that you used in your declaration. You said, I'm reasonably certain that Mr. Kohler is responsible. If you are reasonably certain that Mr. Kohler was responsible, why wouldn't you have, let me just rephrase. You did not apply for a protection order at any point over a year and a half, long past the date of this incident against Mr. Kohler. If you were reasonably certain, wouldn't you not have applied for a protection order much earlier?
No. The reason that I didn't apply for a protection order is because I am in full support of my wife and spouse. I honor her process and her decision. I stand next to her in that process. The nature of trauma and fear in our family was so confusing and
I just object, it's going far beyond this. It was a yes or no question.
It's fine. You don't have to finish that. I understand the answer to the question. And you have another question?
No, Your Honor, I don't.
Okay. All right. Thank you, sir. All right. I'll hear a brief argument.
And Your Honor, I do want.
Oh, that's right. You want your client to testify. I am sorry. Raise your right hand. Swear to tell the truth and nothing but the truth.
I do, Your Honor.
Okay.
Thank you.
So you're going to ask questions or do you want him to make a statement?
I'm going to ask questions. Okay. Mr. Kohler, I want to direct your attention to the declaration that you filed. This all statement you made under oath.
Yes.
In it, you had mentioned that you're a prior employee at Inner City Transit.
Yes.
Okay. Tell me very briefly, were you on protected leave when you were terminated?
I had received notification to require the vaccine by a certain date, or termination would be of October 15th, 2021. I had put surgeries off prior to that. My direct supervisor had to have surgery. We had a lot of transition. So I had talked to my HR director and I said, I put my stuff off for you guys. Sorry.
Just to keep it succinct.
Sorry.
You left, you were terminated when you were on protected leave, correct?
After.
Okay.
So I went on FMLA, had gone and had shoulder surgery, both my wrists done, scheduled to get my other shoulder done. I had returned a doctor's note and it was incomplete. I did not know this. I had given the note a week prior to my administrative hearing. They said if I had the hearing or if I had a note, I wouldn't have to do the hearing. So I didn't show up. That afternoon, I got a termination letter from Ms. Bergkamp stating that I didn't show proof of vaccination and my doctor's note was incomplete. And my doctor had missed signing the bottom. My doctor had asked, hey, can I change this? Like that was my mistake. But the company had known a week that the note was incomplete, where they could have said, hey,
just to keep things moving along, because I know these are expedited proceedings.
Sorry.
Do you believe that you have a potential employment lawsuit against the Inner City Transit?
Yes.
And you've been vocal about that with your friends and colleagues, correct?
Yes.
Okay.
Well, until I've gotten public records and proof of certain things, yes.
Okay. And in the course of your doing public records, have you done many public records requests?
Many.
Okay.
Over 150.
Over 150. And those were those all directed at Ms. Bergkamp?
No.
Were any of them involving Ms. Bergkamp?
Yes.
Who were they also? Who did they also involve?
There was a lot of unethical and some illegal stuff that had gone on, that things that I had known prior to losing employment. Some things were I had answers already to, but I wanted proof from them in their words. They said no exemptions were made, and they had given exemptions.
You're referring to the
vaccine mandate.
Okay.
So there was, I was working from home for 2 years before terminated, but they said they couldn't accommodate me. So there, there was a lot of, I don't have the funds. I lost my job. So I threw out a bunch of public records. A lot of them were just to be able to give to an attorney and say, what can you use? What can't you use? Like, I'll take, I can use, I can throw away, whatever.
So the point of it was to prepare for potential employment discrimination lawsuit, correct?
Yes.
Okay. And that happened to involve Ms. Bergkamp. Did you also have other people involved in your termination decision?
Yes. Anne Freeman Manzanares was the current GM at the time. And Heather Stafford, our HR director, it was their 3 decisions.
Okay. And to your knowledge, have either of those 2 other people who were equally involved in your termination decision had any complaints of harassment that you know about?
Not that I know of, no.
Okay. When did you first learn about this whole key incident?
I actually remember it, I don't know why perfectly, because I was heading up to Spanaway. I was on Shinky Road, and I get a phone call, and I usually don't answer numbers I don't recognize. But I saw a restricted number. I answered it, and the gentleman said, "Is this David Coleman?" I said, "Yes." And he said, "This is Officer Watkins." I was like, "Okay." And he asked me if I knew Emily Bergkamp, and I had stated yes, and what my relationship was. And he asked me if I had heard or had any knowledge of, and I said no.
Knowledge about the key incident.
Knowledge about the key incident. And we probably had maybe a 5-minute conversation. And
did he ask you follow-up questions?
He just asked me, he said, "I don't know if it's you or not, but if it is, would you please stop?" And I was like, "Absolutely." I said, I don't know who it is. I said, there's a lot of angry people, there's some of the public records requests that I have filed are for current employees. And those employees, obviously, in fear of retaliation, can't make those public records themselves. So probably about 15 of those public records are employees reaching out to me because they've seen my post.
Okay, so what you're referring to is other disgruntled employees who are upset about the vaccine mandate.
Yes.
And who potentially some current employees who did get the vaccine over their objections.
Yes.
And so you informed Officer Watkins, hey, there's a number of disgruntled people here.
Current and former.
Okay.
Yes.
To your knowledge, did Officer Watkins ask for any names, or did he do any follow-up?
No, he just basically said, "Okay, well, if it is you, will you just please stop?" And I was like, "Sure." I mean, he asked me that like 3 times. So okay. I was just like, okay,
Yeah.
And that was it.
Okay. Are you responsible for the key incident?
No.
Do you feel compassion towards her and her family for what they went through?
When I first heard about it, it's not gonna sound good, but I kind of chuckled. I thought it was a funny joke. When I found out the extensivity of it and what they were going through, then I did feel that compassion. It was like, I couldn't imagine, because I've got 2 16-year-old girls at the home, and if that was happening at my house,
yeah,
with my girlfriend and her mother, my mother-in-law living with us.
Okay. And did law enforcement advise you that they felt that you were responsible and they were going to charge you with a crime?
Nothing was ever said like that.
In your declaration, you mentioned looking up the incident after talking with the officer and seeing the King 5 news clip. And at the time, you still didn't really understand what it was about, correct?
No, I watched somebody had posted the clip on Facebook, and that's when I clicked on the link to watch it, and it was the King 5 story about it.
Okay. Prior to, last February, last February, you had indicated on a social media post that maybe it was the Olympian, that you had planned to attend an intercity transit board meeting. Can you explain a little bit about that? Why were you going to attend?
Well, I had asked prior to that on, I don't know if it was, I think it was Intercity Transit's Facebook. I asked them, I said, when are you going to open up to public board meetings? I said, COVID's over. Why are you still doing online? And then I believe it was February, I saw the post where they said, we're going to start doing in person, which had been over a year since COVID mandate, everything was over. So I said, great, because I wanted to talk to the board in person with the evidence that I had found about some very unethical practices. And I wanted to talk to them and ask them what was done about this, what's going to be done.
Okay.
And shortly after that is when I got a knock on the door from an officer serving me with papers.
Okay. So,
Mr. McLaughlin, it's been 45 minutes. I'm just making everyone aware of the time. So we have the rest of your direct cross-examination and then closing arguments, which we may not have time for. So if it's something that was already covered in the evidence, let's not go over it again.
I'll wrap it up in the next 5 minutes, Your Honor. And I appreciate your grace with time. Mr. Kohler, there's been a lot of allegations with not any direct proof that you're responsible for this key incident. How does that make you feel?
I honestly have it's been hard because a lot of the people that I was friends with, we're not friends anymore. There's been lots of accusations, a lot of support from Mrs. Burkamp, and I feel like it's a one-sided street because I don't have a chance to defend myself. So it's been hard. Like, I kind of test the waters. If I see somebody, I run into somebody. If they have a smile and they're excited to see me, great. If they kind of give me that look, I just avoid and go elsewhere.
Okay. Have you just been avoiding your normal friends and places that you go?
Not my normal friends, but former coworkers. You know, there's a lot I still talk to, but there's a lot I don't.
Okay. Ms. Burkamp mentioned that her proof that you did this was that it had a Star of David, which would appear to me to be motivated by anti-Semitism. What's your religious and cultural background?
I mean, I'm a Christian. You know, I go to church every Sunday. Very involved with the church, but my grandpa is part Jewish, Czech, Jewish.
Would you ever issue an anti-Semitic threat?
Absolutely not.
Okay.
I mean, there's nothing ever in my posts from previous or even work related that has ever been racist or sexist or.
Okay. The other point of proof that she offers is this Facebook post from November 29th, 2023. Can you exhibit A? Can you tell the court what that was about?
So at my girlfriend back here, her daughters, they're mixed race. they had a lot of issues going on at Reeves. Teachers basically telling them they should be guilty, feel guilty for the white side of them. I had a very extensive conversation with the superintendent and principal. Teachers were reprimanded. Amanda knew about this because her husband is a direct employee of Mrs. Bergkamp.
Who is Amanda?
Amanda Crass. Amanda, because of what I've been accused of, Amanda's been taking it out on my daughter, my girlfriend's daughter. So she has attacked my child 3 times on public grounds.
So let me,
yelled at her.
okay, and go
So-
ahead. So you can finish.
So that night, I finally said, I made a post already, and then Aaron's like, don't use my name, please. So
It's your daughter,
yeah,
Erin.
because she was afraid. She's like, please don't post anything. And I told her, I go, Erin, if I don't say anything, I said, this is going to continue. So she was like, okay. So I made the post, and everything, if you look in here, it's talking about Amanda.
Yeah.
Because she was targeting and attacking my child.
And Amanda is a friend of Miss Bergkamp. Right?
Yes.
Okay.
It's her. At the time, Emily was the operations director. Cameron, Amanda's husband, was the fixed route manager. And so, like, Amanda thinking that's her, I felt like, well, obviously you're acknowledging that you were harassing my child. But
I want to, just for interest
Sorry.
of brevity, do you have any criminal history?
0.
What are your, I believe you were running for office shortly after you left for county assessor.
Yes.
Would you ever do anything like issue keys?
No.
Would you ever do anything like this when you?
I mean,
were running
I'm
for
very
public
involved in the community, and I don't know if I'll ever run for office again, but I'm very involved with, I'm helping Dave Reichert, and, I do stuff with the Republican Party and stuff like that. But I don't know if it's to slander my name for future references. I don't know if it's to keep me away from going to board meetings. I don't know.
or defend against employment discrimination lawsuit.
Yes, or that too. Yeah, make me look.
Have you ever threatened any violence towards? Have you ever threatened at anything? towards Miss
0.
Bergkamp? When's the last time you saw her?
I would guess at least 3 to 4 years ago.
Okay.
It'd probably been at least a year, probably before I was even terminated,
Okay.
because most of our conversations were Zoom or team meetings.
Okay. Have you ever indicated to anybody else that you guys have in common, any ex-coworkers, anything that you have wish ill harm
No,
to Miss Bergkamp?
0.
2 more questions, Mr. Laughlin.
Okay, thank you. Your children go to school together, correct?
Yes.
Have you ever approached Miss Bergkamp?
Never seen her there
Okay.
or her children.
All right, that's 2 questions. Do you have any questions? You're still under oath, sir.
Mr. Kolar, you testified that you are very active in the community. Is that
Yes,
correct?
Yes, sir.
By active in the community, do you mean posting negative and salacious and defamatory comments on Facebook about things that you're involved in the community?
The negative comments and posts on Facebook about your client has been after I've received public records confirming. I would never say anything without having proof.
And you mentioned earlier, testified that you've made over 150 public records requests, correct?
Yes, sir.
And you believe that it is your right to do so?
Yes,
and
sir.
access that information. At what point in the aggregate in a 18-month period does 150 public records requests become abusive process?
Objection.
I
Sustained.
You don't.
Oh,
have to.
sorry.
So your explanation for the November 29th post is that you were speaking of your daughter, correct?
Yes, sir.
Okay. And I'm just going to quote this in full. It amazes me when a racist fat mom tries to bully my kid, then threatens her at a school function. You think that shit's going to fly with me? Should have learned from EB, your daughter. You fuck with my family. It's game on, Amanda. What should Amanda have learned from your daughter? Like, I don't follow what your intention was. Can you explain what you meant by that?
Because I went straight to the superintendent and the principal, and both the teachers were reprimanded, and it was immediately stopped at Reeves from talking about that kind of talked. Amanda knew about this. And so for me, if you don't stop going after my child in school, I will go to the school and I will have, essentially was to say, I'll get you in trouble with the, you know, like I'm not afraid to go to the school and talk to them about what you're doing. I have 5 girls as a witness of what Amanda was doing.
Do you routinely post about other people with such derogatory and vulgar language on the internet?
Not usually, no. This time, like I said, it was the 3rd time, and Amanda walked up to my child at an award ceremony and looked right at her in front of 4 friends and said, "And I'll do it again, try me." So that to me was a threat. And when I heard that, that's when I made the post. And then I deleted that post and then I made that one.
I mean, would you concede that some people would interpret such language, strong language, as threatening or intimidating?
Sustain.
On March 2nd, 2023, you called my client a fraud in chief in a comment, I'm assuming, for an article in the Olympian. Is that correct?
Yes, sir.
And there's a post, it looks like, from March 23rd, 2023, and it says, "I find it so comical when somebody F's with the family and their money and then plays the victim card." What did you mean by that post, Mr. Kohler?
Honestly, that was probably about the key incident because I figured it was a disgruntled employee. You fire somebody. I mean, I was there. I know what the ramifications of losing an income, especially a good income and benefits are.
So, but you just testified a short time ago that, you know, once you found out the seriousness of it, that, you know, you experienced compassion for my client.
Objection. It's a little bit of mischaracterization.
Which one? So that post specifically was about being contacted by law enforcement regarding the key incident.
I believe so, yes.
Okay. And you,
I mean, it's
essentially,
sorry.
no, you're okay. And essentially you're, I guess, saying that my client is playing a victim when she isn't a victim of a crime.
Objection. That's not what he's saying.
Well, I think it's a legitimate question. You might want to rephrase it, but I'm not going to sustain that objection.
And then there's another Facebook comment here where you allege that my client paid off an employee who stole money from intercity transit. Is that correct?
Yes.
And that was posted publicly in a Facebook post?
Yes.
And then
I don't remember it, but if it's there, then yes.
okay. And then there's another Facebook post in which you're talking about being forced to get vaccinated. It looks like generally you're just talking about intercity transit, but then you reference later the new GM and interim GM. Who was the new GM and interim GM at the time you posted that?
That was Emily.
Okay.
Because she was the interim GM.
You called them crooked and alleged that they had committed fraud or theft.
Yes.
In a public forum?
Yes.
Okay.
Because I have proof of it.
There's another Facebook post here in which you're discussing whether or not management is actually doing any work. Is that
Your Honor, I'm sorry, I'm gonna have to object. This is all lawful First Amendment activity. Unless you're.
Your Honor, no more questions.
That can't be subject to an anti-harassment.
Sorry, I just was given a note from the clerk. We do have an 11 o'clock interpreter matter that needs to go at 11 o'clock. So that gives us 8 minutes.
It has to be heard before 11.
Oh, before 11. So we're going to wrap it up.
I have no further questions. I'm ready to proceed to oral arguments.
Okay, so if it has to go before 11, each side's getting 3 minutes. So it's 10:12. You get till 10:15.
No problem, Your Honor. Thank you.
Yeah.
Ultimately, we're asking the court to look at the totality of the circumstances here. All I've heard from Mr. Kolar today is general denials that he is not responsible for these activities. But ultimately, if you look at the nexus of time,
the employment relationship that passed, an immediate ramping up of public records requests after being let go. And then we have this key incident that doesn't go on for indefinitely. It's not still going on, but it goes on for a period of 4 to 6 months, to the tune of 40 or 50 keys that are returned to my client's home by various members of the community, seeking money, seeking a reward, upsetting the peace and quiet enjoyment of their property and their children and her husband. At the end of the day, there's no smoking gun here. But that said, I find the explanation regarding Mr. Kolar's Facebook post to be nonsensical. I do not believe that he was referencing his daughter, and I don't think the court should believe that he was referencing his daughter. I think he, inadvertently or not, was broadcasting to the community that if you mess with me, I am capable of doing things. What those things are, I have no idea. But ultimately, I think that law enforcement thinks it's him, but there's no substantive evidence to get there. We don't need beyond a reasonable doubt today. We need a preponderance of the evidence. And I think when you look at the nexus of time, the nexus of the employment history between them, the aggregate of public records requests, I will concede to the court that it is Mr. Kolar's right to make those public records requests. 150 or over 150, Mr. Kolar says proudly in an 18-month period. At what point do those public records requests become abuse of process? At what point do they become harassment of his former employer and indirectly Ms. Bergkamp? I'm not sure how many specifically reference her, but it seems like Mr. Kolar in his Facebook post, his posts on public forums in the Olympian, in the community, and he has focused his vitriol for whatever happened with intercity transit, regardless of the circumstances of termination of his employment, on Ms. Bergkamp. And now he is set out on a campaign to try to prove that my client is a thief or fraud or not qualified for her job, while many of the things he's doing fall squarely within the First Amendment. At what point does this become harassment? At what point is my client allowed to view this course of conduct as intimidation and insinuation and inference of a further threat? I think that the keys coming into play around March of last year, and the aggregate of that, I mean, it's not 2 keys, it's not 5 keys, it's 10 keys or 50 keys, excuse me.
We're over.
I'll let you go over.
Okay. At the end of the day, we're asking the court to approve the protection order. I think it's warranted. Again, I think that the totality of the circumstances speak to the logical conclusion that there is enough circumstantial evidence directed at Mr. Kolar that the court can make this determination based on a preponderance. Thank you.
Thank you. All right. So 4 minutes.
Your Honor, there's not even circumstantial evidence here. There's pure speculation. The standard of proof is preponderance. We agree to that. The standard of proof for law enforcement is probable cause. There are numerous emails filed by the petitioner which show her trying to get law enforcement to go after my client, essentially, and them telling her, no, they don't have proof. She's drawn your attention to one email after numerous emails to them in which they said they're not pursuing it. That says from one officer who I think had limited role in the investigation that she might think it's him. That's not enough. We're in a court of law. We require proof. None, and I've done a lot of appellate work on these anti-harassment orders. None of the protected First Amendment activities, public records requests, even harsh criticism counts. None of that is harassing activity. The First Amendment provides deep protections to every individual in this country. The timing does not make any sense. That's what I have not been able to wrap my head around throughout this entire case. Why, when law enforcement is repeatedly saying, hey, we don't have any proof here, but you can go get a protection order, why would you wait 1.5 years? Why would you wait until somebody says that they're going to go continue on with their protected First Amendment activity and go to a
board meeting to vocalize their criticism of you. Why would you wait? Why wait? If your family is in danger, why wait? There is simply no proof. It's pure speculation. She supervised 300 employees, I think is what she said. A number of them were highly disgruntled. It could be any one of those people. I'm very sympathetic to what her and her family went through. That doesn't substitute for proof against my client that he is responsible. And the Facebook post, she admitted that Facebook post from November 29th was not about her. And if the court were to grant this, it would impact his ability to go to his kids' games. There's no contact between these people. There hasn't been 3 to 4 years. He's just as impacted by this whole proceeding as by the allegations, limiting his daily life. He's not feels like he can't go out and be in the places he used to be in and with the people he wants to be with, because he's getting these false allegations thrown his way. And this isn't a criminal court, but we do have some level of proof that needs to be sustained, and it's pure speculation here. I'll just repeat that the standard of proof is preponderance, and law enforcement said we don't even have probable cause, which is a lower standard. So as much as I know, and I can tell the court is very sympathetic and should be for what the family went through, that doesn't give us the right to just falsely accuse somebody and just say, well, he's most likely, when there's numerous other people that weren't looked into. Quite frankly, it's a little bit mind-boggling. If it were me, I would have filed for a protection order right away. There wasn't any additional contact. There was no contact. They haven't been in contact in 3 to 4 years. So I would request the court deny it, absent some proof. I mean, I know she put everything she had on the table, but I just don't think it's enough. And judges has impacted my client. It is a big deal to be falsely accused of something so heinous. It's a big deal. And I know this has impacted him. I know it's impacted his family. And now it's having repercussions on his minor children because of a friend of hers. So we would ask the court to deny it. There's clearly nothing ever prohibiting anybody from doing public records requests. That won't stop even if the order was in place. Public records requests are deeply protected. So, Your Honor, we would request that the court deny the petition.
Thank you. Thank you both. So I was looking up a couple of statutes, and it is persuasive that probable cause is the standard for harassment. That would be probable cause for a criminal charge of harassment. The criminal elements for harassment are not the same as a protection order harassment. This court is finding that based on the petition, the testimony, the case record, that the restrained person is engaged in conduct that is against the protected person's rights. So when looking at RCW 9A46020, the definition for harassment, that's quite different than what needs to be proved in RCW. Sorry, I'm going to go back to 7.105. So I am finding in favor of the petitioner. I am granting an order protecting the petitioner. I do find it persuasive. I'm looking at a probable cause, beyond a reasonable doubt. So what I'm looking at is this beyond a reasonable doubt that this harassment has occurred, and I'm considering the following facts. The timeline, it's not persuasive to me that the husband didn't file for a protection order. It's not persuasive to the court that criminal charges were not pursued. Again, those are different elements. It is persuasive to this court that the harassment stopped when a temporary order was put into place. The public comments, the Facebook posts with the initials of the respondent is all persuasive. It's all, in this court's opinion, does meet a preponderance of evidence standard. It may not reach beyond a reasonable cause in a criminal matter, and it may not, to a police officer, amount to what they believe is probable cause for a criminal harassment order. But I'm finding that it is enough, and it is sufficient evidence in this case that there was suffering, there was dealing with angry and intoxicated individuals as a result of the behavior of the respondent, that this family has been hypervigilant, that they have been suffered anxiety, have been anxious, have changed their daily patterns of living, have changed their routines, have had extra family supporting them, that they're basically, I'm finding it credible that they're living in a state of fear based on these actions. I am restraining Mr. Kohler from having any contact with Ms. Bergkamp. I'm also including children in this order.
Your Honor, they go to the same school as my clients.
So when that happens, what needs to happen is the school needs to be notified right away. If they're not in the same classroom, they'll be separated. The school will put a plan into effect that will keep the children a certain distance from each other. If they cannot do that, then you'll have to look at other accommodations. But in the past, when this has happened, these protection orders go to the school, and the school has meeting after meeting to figure out if there's a way to make this happen. I have had children in the same school under a protection order, and there hasn't been any contact. There's usually 1 or 2 lunch periods. There's usually different classes. I don't know the details, and I'm not ruling on that. And that's not before the court, but that is something that will have to be worked out so that there's not a violation of the order.
Your Honor, just to be clear, his children would not be affected as far as it's only him. So I don't know what the school protocol is, and I'm happy to chat with them about it, but the kids would not be protected from each other.
I'm indicating that there is no need for service, and parties will receive a copy of this order today. I'm indicating no harm, no contact directly or indirectly or through third parties of the protected person or the minors. No harassing, following, monitoring, keeping under surveillance, physical or electronic, of the protected parties or the minors. And do not come within 1,000 feet of the protected person or the minors. The protected person's workplace, protected person's vehicle, protected person's residence. With regard to contact with the school of the minors, I'm going to write in there that the children attend the same schools and that can be worked out through the school. You wish to keep your address confidential?
Please.
Not ordering anything with regard to intimate images, electronic monitoring, or evaluations and treatment or personal belonging, assets, finances, or vehicles. I'm not issuing a surrender of weapons, and nothing regarding pets or vulnerable adults. All right, this order was issued today at 10:30 a.m. I've signed the order. You can get copies of the order online or from the court clerk. The court will be in recess. Another judge will be out momentarily.
All right, and Mr. Brown, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, so Ms. Wellman, are you able to hear Mr. Brown?
I can, yes.
Okay, that red lighted thing doesn't amplify, but it collects, you know, it'll allow Ms. Wellman and the record to hear you. So just so you know what that is.
Thank you.
All right, so we're on case 24-188, and I see, Ms. William, you were served. I also see that Thurston County Superior Court has taken a defamation case from some information that was filed here. And as recently as April 15th, there was a denial of your request, Mr. Brown, by this court for an order against Ms. Wellman. And so I looked at previous information that was filed, and I looked at the information that was filed for this case. And there isn't anything alleged, Mr. Brown, from you that is different or in addition to April 15th in this petition.
Your Honor,
So
sorry.
is there anything else?
Is there Officer Lee's Desmond here, 1P85? He said he's gonna help testify on my character.
It's up to
and
you
harassment.
to have people come to court on your behalf, just as it's up to
Yes.
Ms. Willman to do that.
I understand, Your Honor. I did talk to
ask them to
Officer.
be here?
Yes, I did. He said he was gonna be here. When I was,
Did you put him under subpoena or ask the court to send a subpoena? I
He
don't
just-
see that you asked the
he
court to
just-
do that.
he just gave me his word. I saw him when I was, he was going to Ido Avery's house to serve him the petition. And on the way back, I asked him, I told him that the court is on the 17th at 9 a.m. If you could please be here. Since he's not here, I would like to ask a continuum for next time so he has a chance to be here so I can subpoena him.
And what do you expect him to say?
To talk about the issues that's been going on for the past 2 years and how
Anything from April 25th or April 15th when you were last before this court on
Yes,
a
Your Honor, I've
petition?
had a letter received in my mail that I believe is from Lewis Willman and her associates.
Was that what you provided in your exhibits?
The recent
this?
ones. I had 150 other pages that I don't know why I was denied, but I did have a huge list of
So let
conducts
me
of-
get you to answer my question.
I'm sorry, Miss.
Since April 15th, when you were before this court last and the court said, no, you don't get an order against Ms. Woolman. I'm going forward from April 15th and looking at what you filed in this petition alone. And you're referring to, you got another letter that you think is from Ms. Woolman and you think that's unlawful harassment. Is that right?
Your Honor, yes, Your Honor.
Okay.
And
You filed that, and that's what I'm looking at in your exhibits. That's what you're saying
yes,
is the new information.
can I explain why I feel like the letters are derived from her and the situation at large, please?
Well,
if
not the situation at large. I'm
Yes.
asking you to narrow your information from April 15th forward because we've already had a hearing on everything previously. I understand that the court can look back, and I did look back and I reviewed all of what was reviewed previously by the judge because, you know, sometimes these courts of conducts require that look back, but there's already been a decision based on previous information, and it was found that there was not a course of conduct. There was not unlawful harassment committed by Ms. Willman. So I'm talking April 15th going forward, and what you filed isn't providing the court any information.
The letters that were sent, this is why I was trying to have the sheriff here because I knew I couldn't resubmit the papers that were here, but there is a long history of, she emailed.
I understand. I've reviewed the previous petitions.
I know, I'm sorry, Miss.
And we're
I
talking
understand.
April 15th going forward
It's a
now.
letter that was sent that talks about things that's directly related to the case that you wouldn't have any knowledge of unless you're watching the court case in itself. That doesn't seem likely.
This court case or the defamation case?
The one with Ido Avery that I had a petition against him.
Right,
If you
and I
notice on
reviewed
May
that.
17th, she sent a letter was sent at that was sent from Tacoma. That if you would read the letter, you'd see inside of there. She
I'm
delivered the
looking at your
papers.
exhibits,
Oh,
and
sorry.
so
She
direct me here. Something to Megan Lee Russell, member Prostitute Association that's the return address to Grace Monson, member Prostitution Association. So is that what I'm supposed to do? Figure something from? Tell me what that.
Yes, if you
Lies.
notice in there, that little picture on the upper right-hand side of a man pulling his pants down, that was attached to a letter that was in the last petition that was most likely sent from my neighbor saying, stay away from outside the easement. And with that paper was another one that said, court case with Lewis Woolman on there. It was delivered on the same day on that there was a court date in May, I believe. And so I'm just really nervous about this.
Well,
And
right.
in it, if you notice, a lot of the language in there is very derived of someone who would be personal knowledge and knowing about things that are happening and direct harassment towards me. I've never had any issues with harassment until I received till Louis Millman has stepped into my life 2 years ago. And since April 15th as well, I've had other letters being sent to the local bar, which I don't even drink. I haven't been sober 11 years. And a lot of the language in there is saying I'm a violent person. I've never had anything violent on my record.
So you say something sent to a third party at a bar or a tavern?
Is that not the same thing? It's 313 Sussex. I haven't.
Okay, so a letter was sent there. How do you know that?
Because it had my return address and I have the letter at my house. I'm ready to put that into for a PI to get a DNA test done on it. Have you noticed where it's sent from? It's sent from Tacoma.
Mr. Brown, I'm not going to go forward any more with.
Is there any way that it can continue?
No.
I didn't get my
there is
side.
nothing that you're going to present to the court that hasn't already been presented. You've presented all of your information for this petition under 24-188. I've reviewed all of that. As I said, I've gone back because I noticed that there was a hearing April 15th that denied your request. Don't interrupt me. And I see also that Superior Court has taken some jurisdiction. I don't know what's going on there or if it continues on that case. But in this situation, you have provided nothing to the court that is an addition or different than what was already decided April 15th. So
my case will
don't interrupt me, Mr. Brown. Do not interrupt me.
Okay.
I'm ruling as to this case 24-188, denying your request for any order against Ms. Willman. And that's the end of it, is you haven't proven to a legal standard unlawful harassment committed by Ms. Willman against you.
I have 150 pages of the documents.
And April 15th, there was a denial and a consideration of all the information that you filed then and nothing new. Not arguing with you, Mr. Brown. Stop. No argument. I'm done. I've ruled on this case. We have two others to talk about. We have two others to talk about.
And it's been
so we're going to move on to the other two where people are not. Mr. Brown, no,
come here and testify.
No, there is no basis to continue. No good cause. There's nothing that you've presented.
The fact that letters and she's an elderly lady isn't enough of like connective.
Mr. Brown, you've got to stop talking. You've got to stop talking so I can rule, and then we can move on to the other cases.
Your rule is your rule in her favor. I get it.
Finding there's no good cause to continue this case as your witness is not present by 9:30. You did not put them under subpoena. There's no good reason to believe why they're not here other than that they didn't know about this or don't want to be here. And you haven't provided any information for the court to find good cause that this person will provide anything different to your petition. And your petition is wholly insufficient for the court to issue any kind of order against Ms. Willman, given the fact that the court has reviewed all of that information on April 15th and made this decision. I looked for anything.
There's no way all that you guys looked through 150 pages worth of the paperwork and saw that she was not involved with direct. She was messaging the person who stole my animals. So my animals were stolen. This
24-189. Are you ready to move on? Are you going to move on with me?
Can I say my last piece, please?
No, we're going to move on. I've made my ruling.
Messaging the person who stole my animals.
Mr. Brown, you're not listening. We have two other cases to deal with. Stay seated. So you've also asked for, so Ms. Willman, you can be on your way if you'd like. That's the end of the hearing. There is no order issued. I can't hear you, Ms. Willman, you've muted yourself.
I would just like to mention that on Friday, this last Friday, the 14th.
So I don't need any testimony from you, Ms. Willman. I've made my decision. The court will not be issuing an order. There's not a basis.
Yeah, and that was denied as well, Louis.
Okay. So
you lost that case.
So, Mr. Brown. So you can be on your way, Ms. Willman. If you'd like to stay, you can stay.
I just don't want them to talk about me. I didn't say physical. I just don't want them to send any more letters about my family.
We also have your request for an order against Loretta Mullenbry under case number 24-189. I see that she was not served in any way. And have you shown, is there anything you can show that shows that you gave her service or notice of today's date?
I gave it to the sheriff when I left. The sheriff, they know the sheriff didn't serve him. I gave him this stuff.
When did you give them the stuff?
I gave the sheriff when I got the temporary protection.
Okay, so the day that you were before the court, June 6th.
Yeah, I gave it to the sheriff's office, and the sheriff office said they're delivering them. I don't know anything past that.
All right, so when did you last talk to the sheriff about that service?
I talked to a sheriff yesterday, and he said he was on his way yesterday to go give her the paperwork.
Okay. All right.
And he said that they tried throughout the week, but they typically have a Monday through Friday person, but they're doing it on Sunday. They typically don't do it because you couldn't get involved in contact with them previously.
Okay. All right. So as to the Avenerys, that's 24-190 that you've asked for an order against them. And I see that this court has issued an order as recently as May 13th against the Avenerys, protecting them against you. And here we are 3 weeks, not even 3 weeks after that, June 6th, you filed for an order against them.
Yes, this one I do have a lot more information on.
Well, first off,
Sorry.
I don't see that they were given any notice at today's hearing. How did you do that?
I do know for sure that they had got the paperwork yesterday when the sheriff went by and gave it to them.
Okay,
they were
what
home all day.
evidence, what I need is something from the sheriff that says in fact that they did that.
Okay,
I don't have that filed with the court.
Then I don't know, sir. Sorry, I'm very nervous. Let me say that, Your Honor. I know they got the notice on the door.
Okay,
I don't
well,
know.
I need something
anything
more
other-
than
That's all I
that.
have. That's all information. I didn't.
Okay.
I had the sheriff deliver them. I thought the sheriffs were delivering them. That was that, you know. And
Right.
I didn't know I had to do anything else other than and I just come to court. I'm just trying to get these letters to stop.
Okay.
I
Let me
have a
figure
daughter
out,
during
I
a
just see
month.
someone coming in his iPhone. Let me find out who that is. So someone on Zoom is coming in his iPhone. Who is that?
My name's Trace.
And you're here for a hearing?
Yes, ma'am. I think this is the right courtroom.
So what do you think you're here for?
I got a ticket for driving with suspended license.
Okay, you're in the wrong courtroom. And so you need to be either in courtroom, well, I don't know. Look at your notice and it'll tell you what courtroom you need to be in, but you're in the wrong place.
Um,
All right. Do you have a case number on there? Are you able to look at the case number?
Yeah.
But,
His name I can look it up.
yeah. You got a full name for me?
I'm Trace, Trace, Lynn, Lynn, Dorst, Dorst.
So Dorst is your last name, Dorst? Okay.
Yes.
And let's see. All right, courtroom 2. That's where you
Two.
need to go to.
That's not the one I signed into? Sorry.
Nope, send into 3.
I'm sorry.
That's all right.
Thank you.
All right. So as going back to you, Mr. Brown, in case number 24-190, your request against the Avenerys for an order. So Mr. Brown, I'm going to dismiss this action. There's no order issued on your behalf to begin with. We simply set this for a hearing. But the court already issued an order protecting the Avenerys against you.
Your Honor, if you,
Stop. I'm talking.
I'm sorry.
May 13th, and that's in effect until May 13th of 2025. And in your petition, there's nothing in there since that May 13th hearing other than name calling, which is not unlawful harassment. So
What about the
I
letters?
find that your filing for an order against the Avenerys, frankly, is vindictive and there is no basis. So I will not grant this
I haven't been able to
request.
talk my side. I have the letters I
Because there is
sent.
no,
There is
there's
the
nothing
letters.
for
If
the
you look at
court
the
to
image
do,
right
and I
there,
find
if you
it's
look at the image
vindictive
right there, with the guy with his
filing
pants pulled down,
with
he
no
put a
further
letter in my
information.
mailbox saying, "Stay with me, your neighbors."
So, Mr.
With it, there
Brown,
is more than
I know you
proof.
disagree.
No, I
but
just want to speak my side. I haven't
We've
been able to
already
say my
had that
side.
hearing on the Avery matter on 190 back on May 13th, and within 3 weeks, you're filing for an order against them.
Because of the letters they sent. Look
without
at the
any
letters.
information
If you,
that supports this.
I've
And the
been-
letters that's been sent is not sufficient information for unlawful harassment. Even if I were to believe that that's what this is, I find that your filing against them
I
is
just want these
vindictive.
letters.
So we'll
It's not
move back,
vindictive.
we'll move back to the case that you filed for an order against
Who
Mullenbry.
is still logged in? She has no reason to still be logged in.
Yes, she is. It's a public hearing. Anybody can watch.
She's
Anybody
doing
can
this
be
so
in
she can
court.
do more things on the letters.
So,
I guarantee you
case
there's
number
things on the next
24,
letters can be
case number
involved in this hearing.
24-189, your
It's
request
denied.
against the Mullenbry, Ms. Loretta Mullenbry, not served. I'm just, we're gonna strike the hearing. You can always refile if you feel the need, but you haven't shown any service of notice of this hearing. There hasn't been an order issue.
I haven't been able to say anything.
They're not
I've said
here.
2 words.
They're not here and you haven't shown
With any of these
service.
cases.
And
miss,
so
I haven't said nothing.
We're
I
striking
have,
this
I
hearing
have so much
and
information
dismissing
here.
this action.
I have information regarding to her and the person who stole my animals. I have
And
150
we've heard all of
pages.
that going back to May and
Your Honor,
April.
you did
So,
not hear any of this.
This court did and made
No,
decisions.
it did not.
I'm
take
not
my
arguing
court.
with
It
you
didn't
anymore,
take-
Mr. Brown.
I didn't present my
If
court
you
on the
feel the need to
13th.
file
I'm not
petitions, then
arguing.
you
I'm just
need to
telling you what
provide
happened.
evidence.
I never went to court on the 13th.
These are
They-
dismissed. The hearings are stricken. Cases are closed. Time to go. Time for you to go.
This isn't right.
Time for you to go.
I'm getting harassed by these
Follow the
people.
orders that have been issued
Your
against you.
Honor, I should be able to present my
Time for
case.
you to go.
I should be able to present my
Time
case.
for you
I
to
have
go,
not been able to
Mr.
present my
Brown.
case at all,
Go.
And this is not okay,
Leave the court.
okay? I've been getting harassed. They've left
Leave
bullets
the
in my
court,
mailbox.
Mr. Brown.
They put
Leave the court
They sent
now.
a gun man to my house. and I don't
Leave
think
the
there's
court
any-
now, Mr. Brown. I'm gonna tell security to make sure he leaves. You and I don't know. All right. Okay, so how this goes is I'll be turning first to the petitioner, the person who started this action, that's Ms. Aleph, and see if there's anything more other than what I've read in the petition that Ms. Aleph has filed and exhibits that she may have filed. And then I'll turn to Ms. Saxton, and I'll hear from Ms. Saxton, see if there's, in response to this request, that now there is a temporary restraining order against Ms. Saxton, and the question is, does that continue or not after today? First off, my first question, Ms. Aleph, are you asking the court to have an order after today?
Yes, ma'am, I am. So,
Okay, all right, Ms. Saxton, let me ask you, do you object to the court issuing this order after today?
yes, ma'am, I do.
Okay, now we know where we are. So Ms. Aleph, you say this all happened at the White House Bar, White Horse Bar, and tell me anything other than what you wrote in your petition that I need to know.
Basically, ma'am, we don't know each other. We're not close together. We've run into each other at the bar twice, and I just want to be left alone. That's it.
All right, so you say last fall, which means fall of 2023?
Yes, ma'am.
Okay, so
And
you're
that's
at
how you can see
the
the
White,
images.
I'm sorry, what?
That's where the images came from.
Okay, okay. So those go back to last fall, the email exhibits, or
Correct.
the pitch?
The images should be an image of my neck and my husband's neck.
Okay, that was from last fall. So tell me
That
what
was-
happened then.
That was from November. I had mistaken one of Bridget's friends for somebody that I knew. I approached them, touched her, she got offended, we got separated. When me and my husband went to leave.
Who did you touch? Did you touch Miss Saxton or someone else?
No, her name is Chloe. I also didn't know her. She looked similar to somebody I did know, and I thought it was somebody else. When I left the bar, Bridget, Chloe, and another third person that I still don't know who it is, attacked me. We had let it leave. We were just going to let it blow over. And 3 weeks ago, I was walking through the bar and Bridget grabbed my arm and told me that she was the one that beat me up in the parking lot. And she didn't want me to forget it.
So that's how you knew that it was Miss Saxton.
I knew it was Miss Saxton back in November, but I didn't want to bring it any further. I just wanted it to go away.
Okay. All right. And so since last fall and June, so 6, 7, 8, 9 months, would that be fair to say? 9 months? Okay. So there hasn't been any, have you been at the White Horse Bar since that last fall event?
Me? Yes.
Other than June? Yeah. How often?
About once a week.
Okay.
We're good friends.
I'm sorry, what?
We're good friends with the owner of the bar.
Okay. And then in that 9 months or so, did you see Miss Saxton there other than in
I
June?
would have never been able to point her out in a crowd.
Okay.
Until she grabbed me.
All right. So in fall, you attribute the scratches to your neck and your husband's neck, but this is a petition by you, but you attribute the scratches to your neck to Miss Saxton. Can you describe that more particularly?
My husband stated when he came outside to follow me home, that I was being held down by Bridget by my neck, and he had to push her off of me.
So you remember that?
I don't.
You don't remember that? Okay, because I can't accept your husband's statements without him being available for the court or for Ms. Saxton to talk with.
I could arrange that too.
Yeah, well, today's the hearing date, and that's what this is about. So I expected that information be before the court today, and of course, Ms. Saxton have that opportunity today to deal with this. So, all right, you don't remember. So tell me a little bit more about last fall. So you didn't remember what happened, but you did end up with scratches on your neck. And
Correct.
You knew someone did that to you from the bar.
Correct.
But you only know that because your husband told you?
Because she also messaged one of my friends saying that it was her that did it.
Okay, and that was before the June information. That was sometime between last fall and June. There was act.
Yeah.
Okay. So a third party tells you that they got a text message from Miss Saxton that says, "Yep, I did those scratches on Charity's neck."
Correct. Yeah.
And then any of that information in your exhibits?
No.
Okay. All right. So what more do you recall or know from the last fall event?
That's it, ma'am.
Okay. So, and then from last fall until like June, early June, you didn't have any contact personally from Miss Saxton. Is that right?
Correct.
Okay. All right. And then your petition says exactly that I'm just getting back to the statement that you're back at the White Horse on June 1st, and Bridget grabs you and says, "Don't forget, I'm the one that rocked you in the parking lot." And did you know, is this the person that is here appearing on Zoom? Is that the person that
Yes.
said that to you June 1st? Okay.
Yes.
And what does rocked you in the parking lot mean to you?
That means that she was admitting and not wanting me to forget that she's the one that attacked me in the parking lot.
Okay. All right.
I actually did call the police that night. I did make a police report over the phone.
All right. I remember that being, was that in your exhibits?
No.
So, yeah, mostly I've gotten exhibits from, looks like I have a few email exhibits from, and we'll talk about those when we talk with Ms. Saxton. So can you tell me anything more about the June 1st event? You were just at the bar, and what happened
That was it. That was it. After that, I left the bar because I was no longer comfortable there.
So you were just sitting with friends or alone, or what?
I was walking by myself back to the inside when she grabbed me.
All right. So you were walking.
After I pulled, I went and found one of my friends, Crystal, and she brought me across the street to get away.
Okay. So you were walking back into the bar from the parking lot.
Correct,
So this happened
yeah.
in the parking lot.
It happened in the smoker area out back.
Oh,
They
okay.
had fans there that night that we were watching.
And how did Miss Saxton grab you?
She grabbed me by the arm, pulled me to her, and then reminded me that she was the one that beat me up.
Okay. All right. And so before last fall and before June 1st, sounds like you didn't know Miss Saxton.
Not at all.
All right. And no contact with her since between when you believe she attacked you and June 1st when she grabbed you by the arm again.
Correct.
Okay. All right. Do you have any idea what this is all? I mean, you say it's something about Chloe back in the fall.
Mm-hmm.
And you don't have any do you have any recollection at all about what happened last fall, or it's all just from your husband telling you what happened?
I'm sorry, I don't have the recollection.
Okay. And is there anything in any of the exhibits or that would, anything else you want to expound on or point me towards, or?
Again, I'm only wanting to get this just so I can be left alone. I don't want any harm for Bridget. I don't want any harm for anybody in our family. I just want to be left alone. I want to feel comfortable in my hometown. And I'd prefer us just go our separate ways and it didn't have to come to this.
Okay. And the White Horse Bar is in Rainier?
In Yelm.
In Yelm. Okay. And you're, all right. And you're in Yelm.
Correct. We're both in Yelm.
Okay. And all right. So I'm going to turn to Miss Saxton, see what response to this order is. And Miss Saxton, what would you filed a few things, but what would you like to say in response, and point me to what I should take from what you filed?
Well, I did not assault Charity, neither November 17th or June 1st. I arrived at the White Horse about 10:30 after a show in Tacoma with my.
So what day are we talking about?
November 17th. My niece Tranquility, her partner Allison, and Chloe and I had been at a show and dinner in Tacoma and arrived at the White Horse. They were taking me home to have a couple drinks, finish out the night. And as soon as we arrived, I hadn't even gotten out of my car yet. And Chloe was screaming at somebody I assumed was a man because she was telling him to stop. I don't know you. Don't touch me. Stop trying to kiss me. Get away from me. You don't get to just touch people like that. And I'm assuming it's a man. So I rushed around to see that it was Charity, and her husband was standing right there. He was now yelling at Chloe, telling Chloe that she shouldn't be yelling at his wife that way. Don't talk to my wife that way. And then I addressed Charity and said, "What? You don't get to touch people. We don't know you. That's not acceptable behavior. You cannot do that. We don't know you." She got in my face. She chest bumped me. She was spitting in my face when she asked me what I was going to do about it, old lady. And I pushed her out of my personal space. She was touching me when I pushed her off of me. No sooner did I push her off of me than her husband tackled me to the ground hard, I smacked my head on the concrete, bit my lip, bit my cheek, bit my tongue, busted my tooth. And I mean, this happened so fast. As soon as I was on the ground, my niece and Chloe and Allison, my niece's girlfriend, were trying to remove him off of me. And then Charity jumped on my niece's back and started pulling her hair. Tranquility's back, started pulling her hair. So they moved them to move Charity off of them. Orion had gotten off of me, so I was working my way to a standing position. The bouncer came outside, told them they needed to leave because they had been cut off. They had already been causing a problem and were cut off. They needed to leave and instructed us to go into the bar. And that's where we found out that they had been cut off and what their names were, and proceeded with the rest of our night and then went home. I never rocked Charity. Nobody rocked Charity. She was pushed off of me, and then she was pulled off of Tranquility. They were 100%
after this resolves, and given that the information you got from the bartender and so forth, that again, we don't have that person here to talk to. I'm not going to consider that statement that they were cut off or any of that information, but your recollections, your observations, I will consider. So, so then between November 17th and June 1st, any contact did you have with Charity?
I did not contact Charity and had no contact with Charity. However, the next day, in an effort to find out why they were looking for videos and accusing us of things, I contacted a young lady who calls me her aunt and is Charity's friend, because we are in a small town, and wanted to know what was going on and to inform her what the situation was. I probably have those text messages between me and this friend of Charity's.
Well, you can tell me what you said.
But I don't need to. I don't feel I need to. We figured it was a drunken episode and just we're going to let it go. We figured Charity and Orion were obliterated drunk, and we were just going to let the situation go. Whatever. They're gone. It's over. Finish out the night and go home. My son's girlfriend performs often. She's in a band. She's also a bartender at the White Horse. So my son is there. My family frequents this bar regularly together. And I'm also friends with the owner of the bar. Again, small town. So restricting me and my family from going to watch my son's girlfriend sing, which is something we do often, is where the only reason I'm even objecting to this. That, and I work with the general public and the vulnerable citizens of our community, and need to be able to access every building that they need to access, because I take them to their doctor's appointments, shopping, eye appointments, nail appointments, hair appointments, all of the things.
Let me ask you about June. So June 1st, we've got in the petition, as you read. Talk to me about what happened from your point of view, June 1st, if anything.
We arrived at the White Horse at about 6 o'clock, and we're sitting in the beer garden. It's a really large beer garden. I would say 24 by 36 feet. It's a large beer garden for my son's girlfriend's performance that night. And Charity was sitting on the other side, so probably 18 feet away from us. There was no communication with us at all until Charity and her friend walked up to our table for no reason. We have no idea why they were, hours later decided that they were going to approach our table. There was no need for that at all. It's a large area. She could have gone anywhere. She did not need to approach us. And I said, Charity, do you remember me? And she said no, which I find false, because her friend Myra had walked up and said, "Are you Bridget?" and shook my hand when I said yes. I don't remember what else she said, but she shook my hand when I told her yes, I was. And I said, Charity, do you remember me? And she said, no, I don't. And I said, I'm the old lady that your husband dropped in the parking lot. I never said I rocked her. That's not something that's in my vernacular. That that just wouldn't come out of my mouth. It sounds strange to even say it to you. I did tell her that I'm the old lady that her husband dropped in the parking lot. I did not grab her. This was witnessed by multiple people that were sober at our table. And I feel like she's embarrassed by her behavior and trying to cover with this petition.
So that didn't happen. You agree that you were at the bar?
Oh, yeah.
But after that,
And there was an interaction, but I never touched her.
Okay, all right. And since June 1st, then you received notice of this hearing and that order and no contact since?
Yep.
All right. All right. Anything else, Ms. Saxton? Anything I should know?
No, other than the letters that you have in front of you from my friend who witnessed everything, a character witness who's the lead bartender of the White Horse, and her interactions with Charity, and my niece who was with me on November 17th.
Right. So I'm not going to consider those because they're not under oath. Those people aren't here for the court to question and to evaluate credibility. Ms. Aleph can't evaluate their credibility or question them. So I can't consider those because you probably heard the term hearsay. And yeah, so I can't consider those, but I certainly can consider everything you said. So I'm just going to, Ms. Aleph, I'm just going to jump back here to wrap up here. Anything new or
I have since stopped going to the White Horse because I don't want to cause problems with them. I will stay away from there, Bridget. I'm not trying to hurt anybody. I just think obviously we do have some animosity, and I think it would be helpful for us to have a tool to keep us apart.
All right. Well, I think the tool is simply your commitment not to contact each other, and I'm hearing that. So I don't see that there is unlawful harassment here. The last fall event, unfortunately, fairly and honestly, Ms. Aleph has said she doesn't recollect, doesn't have any personal information about that, has heard from others. And now I hear a much different rendition of the event. And then June 1st, again, you both agree you're at the bar, but a very different rendition of what happened there with a lack of really understanding who is affecting or doing things to you, Ms. Aleph. So I don't find that there's a substance of evidence, legal standard, that there's been any unlawful harassment committed by Ms. Saxton against you. So I'm denying and dismissing this order as it exists. It ends today. I'm denying any further order. Now, again, Ms. Aleph, you're right. The tool is the two of you just don't contact each other. That's the tool. And that's the end of the hearing. I'll sign an order. As I said, Ms. Saxton, then that order ends today. And I'll put that in the court file. So each of you can access the court file from your Zoom instructions if you want a copy of this order, or if you have difficulty there, you can certainly contact my clerks directly and they can assist you. But that's it for today.
Thank you.
Thank you, Ms. Saxton. Thanks, Ms. Aleph. You can both be on your way.